going inside the issues of our community. This is Local 12 Newsmakers.
I stand before you to confess the worst mistake in my life. From December 1999 until August of 2003, I was involved in an extramarital affair, a mutually consensual relationship with a female lawyer with whom I had worked with in the prosecutor's office.
Good morning and welcome to Local 12 Newsmakers. Mike Allen, one of the most powerful politicians and government officials in the county, surprised everyone with his announcement on Wednesday. The next day, Rebecca Collins, an assistant prosecutor, filed a suit in federal court which provided disturbing details to Allen's admission.
To pursue her, she tried to break it off a number of times, and he relentlessly pursued her. He called her, he came to her office, he came to her home, unsolicited gifts and flowers and all kinds of things, and it just progressed to the point where she felt like she had to take a drastic step.
The facts of the relationship of Allen and Collins is not the immediate focus of this morning's program. That will be worked out among the lawyers and possibly in court. In an effort to use this moment in a responsible way, I've asked two people to join me this morning to talk about the larger issues of workplace relationships, sexual and otherwise. Jennifer Branch is an attorney with the firm of Laufman and Gerhhardstein. She practices civil rights litigation in the areas of race, sex, disability, and sexual discrimination, prisoner civil rights, and abortion rights. Bill Hart is the president of the Employers Resource Association, a nonprofit trade association specializing in human resources and providing services to the 1,250 member companies here in the region. Welcome to Newsmakers. Thank you for being here. I went back and in Mike Allen's statement the other day, which was 2 minutes and 35 seconds long, he used the word consensual 4 times. That was certainly a theme that he was trying to set. Does it make a difference that a relationship is or is not consensual?
Absolutely. Sexual harassment is defined as unwelcome sexual attention, touching, anything that an employer, coworker, supervisor does to you that you feel is unwelcome is sexual harassment. If it's welcome and you want it and it's consensual, it's not sexual harassment. From
a legal perspective.
Right.
Now, Bill, can a company or an organization make a policy that says even consensual relations, sexual relations between employees is not allowed in that company? Can you go beyond the law?
Sure, absolutely. Most companies, however, will probably not ban it completely. Most companies will put some types of restrictions on dating and supervisory relationships, people reporting to each other and so forth. But in reality, their policy could say that we do not want anybody in our employ having consensual relationships.
So in a policy situation, as opposed to a legal situation, for example, they might say, because what we have in this situation and what we know is that we have the head of an organization developing a relationship with somebody who started out as an intern. And so an organization might say, we're going to restrict certain relationships, but if two people are on the same level, that might be okay.
Sure. In some cases, yes. In other cases, perhaps not, because levels have a lot to play in whether or not you can prove sexual harassment. If somebody's in a power situation over another, there becomes a very good question of what that created. You can also have people that are on the same level who have consensual relationships, and it may not create a problem until it turns bad. When it turns bad, it generally gets bad.
But you should also be careful because the employer, the company's liability is different, whether it's a coworker or a supervisor. The company is 100% liable when a supervisor is the one doing the harassing. There's no defense to that. When a coworker is doing the harassing, the company can have a defense. Hey, we investigated the complaint and we looked into it and we solved the problem. We're not at fault. You might sue him for sexual harassment, but you can't sue us. But when it's a supervisor, they don't have that defense.
Okay, so the levels of people's jobs really does make a difference from a couple of different angles. On this consensual, because Bill sort of raised this before, what if a relationship starts out as consensual and then somebody wants, and it ceases to be consensual, as you were indicating before? Can that be possible, and then does everything change from a legal perspective?
Absolutely, and no means no. In any type of sexual relationship, a woman can say no at any point. Just like date rape gets confusing because they start out going back to the room, having a good time, and then all of a sudden she says, hey, stop, I don't think I want to do this anymore. Well, at that point, there's no longer consent. And if it's sexual harassment and they've been dating or flirting or even having a full relationship, and she says, no, I don't want to do this anymore, and the employer, the supervisor, continues to persist and then affects her job, I won't give you a promotion, you're going to get a lower evaluation, you're going to get a pay deduction, then that becomes sexual harassment.
From your organization's perspective, when you work with an organization to develop policy, do you have sort of the ideal policy that your organization thinks ought to be the standard, or is it really a company-by-company situation?
Well, a company can establish its own policy. When you get into potential problems with these issues, if somebody's looking over your shoulder, they're going to look at the content of your policy. They're going to look to make sure that you've got some of the things that are required to have an effective policy.
For example?
As an example, if you make it very difficult for people to come forward to report claims of sexual harassment or any other harassment, if you make that difficult, if you make them put it in writing, and if you make them run through 6 loops, somebody's going to say, you know, you're not really making it very comfortable for somebody to come forward, especially somebody who may be in an inferior position. So a good policy is going to address the fact that this is illegal activity, it is a violation of company policy, it will be addressed, and anybody found guilty will be disciplined appropriately. We encourage you to bring forward anything that you see or anything you're subjected to. We will investigate it. We will investigate it as confidentially as possible, and even going so far as to indicate who specifically one should go to. Again, alternatively, some people may say, well, I can't go to him because he's the one doing it. So you're going to have another option for him. You're going to have to say, this is not the only avenue you have.
Does the person who feels they have been harassed, do they have responsibilities as well as rights?
Absolutely. The first thing I would recommend to somebody who feels like they've been harassed at work is to talk to somebody that they're close to, who knows them well, to get a reality check. Because so many women say, you know, I felt creeped out by it, but I'm not really sure that's harassment. Did he really mean it? I don't really know. So talk to somebody, get a reality check, make sure you're not overreacting. But if you trust your instincts, then go ahead and report it. Go find that policy. You know, whether it's on the bulletin board or it's in your handbook or there's an 800 number somewhere to call, follow the policy. When it's co-worker sexual harassment, the employee must follow the policy. If it's supervisor, they don't have to, but I always recommend that you do because it makes a record. It puts the employer on notice. And if the employer looks at your complaint and does nothing in response, and the harassment continues and escalates and you end up getting fired or you lose your job, then the employer is going to be liable.
If I could add something to that, Jennifer, one of the things that when we do training for employees, supervisors, managers, we tell everybody, you probably don't have to do this, but we believe it's a good thing to do. If you're subjected to this, tell somebody, this bothers me. Tell the person that's doing this, don't do this anymore. Now, that doesn't guarantee that it's going to not happen. It doesn't guarantee that everybody's going to feel comfortable saying don't do that, especially if they're in a reporting relationship. But it puts that person on notice that I don't like this. It's going to stop. And I'm telling you, I don't like it. Now I'm going to go report it to the Human Resource Department or the president or whoever the case is.
And I think that's good advice, especially when it started out consensual, because you have to have a clear moment and say, no, stop. And it's hard, though, for an employee to go to their supervisor and say, stop, I don't like this anymore, because what you really find is people go along to get along. Mm-hmm. And then the employer who's doing harassing or the supervisor thinks you must enjoy it because you're laughing back. You might be laughing back outwardly, but inside you don't ever want to be in this relationship again. You don't want to go to this meeting ever again. I don't ever want to walk down that hallway. And it is much better to be able to confront the harasser, but that's hard to do.
What responsibilities do other people in the workplace have, especially if it's not a single incident, if it's a long-term incident, and you're observing things that you think may be inappropriate under the policies or under the law? What responsibilities do you have as someone who's not immediately involved in the situation?
Well, I don't think there's a legal responsibility, but if you're friends with the person being harassed, I'd recommend talking to them, seeing if you can encourage them to report it and come forward, because so many people are afraid. They don't know that their HR person is going to take their complaint seriously. They're afraid they're going to get retaliated against, that everybody's going to be mad at them, that their job is going to get worse. And even though retaliation protects them, they sometimes need that support of other people in the workplace.
How's that handled in company policy sorts of things?
Part of what we try to help companies with is a sensitivity issue. To try to sensitize all employees that even if this isn't happening to you, if you see it happening to anybody, we want to stop it. We want to know about it, and perhaps that person's not going to come forward. If you can get all employees at a company to understand that this is wrong, it's not like it was 40 years ago. This is wrong. And if I see it, I'm going to let somebody know. Sensitivity to these issues from everybody helps everybody in turn.
You know, you say, you just used the phrase, it's not like it was 40 years ago. And there's a lot, even on the phrasing level, you know, the Girl Friday sort of image. A lot of people's reaction to this sort of situation is, gee, it seems like you can't do anything anymore. You can't give anybody a compliment. You can't, I was just trying to be nice. You know, everybody's got to be worried about so many things.
The problem, Dan, is perception. The problem is perception. Perception is reality. One thing that you say or do to Jennifer might not mean a thing, but if you say it to Sally, Sally might not perceive that as differently, and she might think, that's not right. I don't like that. If one person doesn't like it, you need to stop it. You need to stop it, and the company is responsible for that because you're actually an agent of that company. So the sensitivity issue, and I keep using that word because it's an education, but everybody has to be sensitive and everybody has to understand this has no place in the workplace.
One of the issues here is that in this case that is immediately before us, the suit was filed in federal court. Why does this become a federal issue?
Plaintiffs have a choice. They can go to state court or federal court because they're suing under Title VII, which is a federal statute, and also the county is a defendant here. That makes it a civil rights case. Those cases are normally filed in federal court, although they can be filed in state court. And it's an equal protection case. I'm assuming the argument will be that she was treated differently than other employees in
and that's certainly what the suit says. I mean, she was treated differently.
Can I just respond to the
Sure,
the 40 years ago? Because I do think that sexual harassment law gets a bad rap. People are allowed to date at work. They're allowed to flirt with each other as long as it's wanted. When it becomes unwanted is when it should stop. And sexual harassment has to be severe, and it has to be pervasive. It can't just be a couple of off comments or a brush against you that you report and it never happens again. That's not sexual harassment.
So the one-time comment, the one-time brush, I can't be sued for that?
Right. That's not a claim.
That's not a claim. Okay, so we don't have to be super tied up about
No,
this.
but if your one touch was you groped somebody's breast, then you are going to be liable for that. If it's severe, if it's a one-time severe harassment, or if it's pervasive, then
I'm almost out of time, but one question I want to ask is, in this lawsuit, as I understand it, it's not just Mike Allen who's being sued, it's the county that's being sued, which means all of us. Why is that?
The county is the employer of Mike Allen. The county is the supervisor of Mike Allen, and the county may or may not have a policy in place that allowed this to happen. I mean, she sounded like she had trouble who to report this to. If she was supposed to report it to, under their policy, to Mike Allen, well, that's not much of a policy.
Which is the point that Bill brought up earlier. There has to be alternatives to make sure it works. Right. Thank you very much. Obviously, we're all going to live with this case for a long time, and we live with this situation every day when we're in the workplace. So thank you for being with us.
You're welcome.
Stay tuned. Across the region, teachers have spent weeks preparing for the return of students. After the break, 2 local systems that seem to have some answers about how to help students succeed. For the last few weeks, and especially this past week, teachers have been welcoming students back to school across the tri-state. Last Tuesday, Ohio released its annual report card on the success of schools and school systems. With expectations and energy levels high as the school years begin, what do we know that might make this a more successful learning year for more students? Welcome back. So often in the news, including this show, unfortunately, we focus on the problems and the failures faced by schools. What jumped out to me when I saw the scores released by Ohio this past week was the number of districts ranked as excellent. Districts that met at least 17 out of 18 standards. Many are smaller districts with distinctive upper middle class and upper class demographics, places like Madeira, Indian Hill, Marymount, Wyoming. Others are larger but solidly upper middle class suburban districts. 2 didn't fit the expected profiles, at least in my mind, and therefore are even more interesting. I am joined now by David Gibson, the Assistant Superintendent of the Reading Community Schools, a small urban district with a mixed economic and social demographic, and Dr. Jay Kemen, the Director of Curriculum for the Oak Hills Local School District, a West Side suburban district. Welcome to Newsmakers, and congratulations. You must feel good about that news. Everybody waits to hear what that's going to be.
Absolutely.
Well, David, let's start out. What do you know? What are you doing right?
Well, I think part of that, Dan, is that we've started with great people. We have talented teachers. We have great kids. And then you take that and you add some focus, and that's really, I think, the secret to our success.
And what does that mean, focus?
We know what the state of Ohio is expecting of us. We have now spent a lot of our energies, focused our energies, our professional development money in creating and working with alignment of our curriculum, taking the expertise that our teachers have and bringing that together to work on that alignment, knowing what we need to teach boys and girls, committing the time to do that, committing the resources. And I think that's paying off for us, is bringing that expertise to a point.
Jay, what about you? How would you describe what it is that you've been doing that got you here?
Well, I think it is, much as David said, kind of a commitment to helping our students kind of attack and approach these many educational hurdles that the state and the federal government have put before them and before us. And really, we have certainly worked over the years with aligning our curriculum and our instructional practices to meet the standards. We very much are focusing on every child and using data, very specific data, so that we act in a very knowledgeable way in our instructional practices and what we do for each kid.
Both of you talked about the importance of aligning your curriculum with state standards. I taught long ago in a very different environment, very different situation. As an old-time teacher, is there any reason to worry that those standards that you're aligning with don't really, in the long run, are they the right standards, or are we just teaching to the test? Is there a difference between aligning standards and teaching to the test?
Well, I'll start and then you can follow this one through. First of all, I really don't like, and I've tried to encourage all of our practitioners not to think about teaching to a test. What we do is we give skill sets and knowledge capacities, thinking and understanding, comparing, contrasting, pulling out, synthesizing ideas to our students, so that whether it be the Ohio Proficiency Test or Achievement Test, SAT, PSAT, ACT, or in the future on the job, they will have the knowledge and be able to bring to bear their education to serve them. Teaching to the test is a very, very kind of naive way to think about these processes. And my own professional experience with the state model curriculums and the direction they're headed is they're extremely well founded. I can't say that was true even 5, 10, certainly 10 years ago. The model curriculums the state had were very biased and not well thought through in most situations. Today they are really quite rigorous in terms of their what goes into them, who produces them, the thought behind them. And, you know, while you might argue a couple points here and there, by and large, I think if you are knowledgeable about what curriculum is, you would find comfort in the state model.
Would you agree with that?
I would agree. Our philosophy at Reading is it's good learning. From what we've seen, Jay spoke of the ACT. Ohio's ACT scores are higher than the national average. Is that just smart kids live in Ohio, or is it the fact that these outcomes, these expectations are good learning for all students, and that's our focus.
You know, something I think is very difficult for those of us who aren't immediately involved in education is there's a whole bunch of different standards floating around here. There's the state standards, and then there's the No Child Left Behind, and sometimes schools that do very good on the state standards can be judged as falling behind on the No Child Left Behind because of the way certain things are done. How do you deal with that?
That is a challenge. The one compelling fact about the state standards, and there are going to be 23 performance indicators for the state this year, they are uniformly applied to all schools, all grade levels where an assessment is. The No Child Left Behind criteria is not uniformly, it is uniformly applied, but it is not applicable to all. So there may be segments that David has to worry about to fulfill No Child Left Behind requirements that I don't, and the converse.
Is that because of the demographic makeup of a school? So if you have there's No Child Left Behind, you're not only judging the test results, but you're looking at the test results for African American males, African American females, Caucasian. Is that what we're really talking about here?
That helps, I think, a smaller district that has less diversity in it. Because of those differences.
But you have a fair amount of diversity,
yes,
don't you?
Yes, sir, we do. I don't think we're terribly out of line with any other district in the percentage makeup of how we, of our schools and our school district.
It's actually a two-part piece. It has to do with the demographics, the style or texture of your student population, but it also is definitely a segment of size. If you are a small building, for example, many of the criteria of No Child Left Behind simply will not be applicable. You may do really well with those students you have, but if you don't have sufficient students in a certain population grouping, there's no indicator. It simply doesn't apply. And then the building next to you might have just a few more and therefore apply, and they may do really well or they're better than you, and yet the AYP may say, gee, you didn't get to the mark.
How important are certain things that we hear a lot about? Small classes, teacher pay, all of those sorts of things. Well, let's take small classes. And is there a magic number that we've learned? When I taught at LaSalle, I had one class with 47 students. Now that was nuts. We have only about a minute left.
I don't know about the magic number, but I think for us, I think small class sizes is important.
And what do you try to stay at?
We have historically stayed right around 20 or maybe even less in some
and is that did you have to bring it down in the last few years to get there?
Actually, that has been a part of a commitment made back in 1997 by the school board.
Okay, and I'm almost out of time. In Oak Hills, what about class size? How do you think about that?
Well, I think class size is always relevant in terms of our being able to personalize our instruction for students, but it's also a factor of the kind of resources that we need to bring to bear and how we're going to use that. So, you know, that's that trade-off. It's kind of back and forth both.
Okay. Thank you very much. Congratulations.
Thank you.
We'll all be watching you and how it turns out next year.
Okay.
Thank you for making Local 12 Newsmakers a part of your Sunday morning. Next week is Labor Day weekend, and it is the one Sunday a year Newsmakers is preempted for live coverage of the U.S. Tennis Open. In 2 weeks, we begin our coverage for elections. Have a good week.